Okay, we're going to go ahead and get started. This is the public meeting for the Fort Union Subdivision of the Utah Lake and Jordan River General Stream Adjudication. My name is Gary Brimley. I'm an adjudication engineer at the Division of Water Rights. And just briefly, I'd like to thank you for coming tonight and point out and thank a couple of people who are in attendance. Over in the rear we have the state engineer, Kent Jones. In our door frame here is one of our team leaders, Ashley Ostraff. Over at the back of the other side of the room is John Bream, another team leader. These people are the people who will be collecting and examining and reviewing water users' claims in this process. And again, at the other door frame is Mariah Gamache, who's also an engineer at our offices. And the agenda tonight is we'll be going over the adjudication overview, so sort of definition, what it is, what it's for, what we accomplish. We'll kind of define what water rights are, and then we'll go into the proposed determination process, which is what applies to what we're doing tonight, which is regarding this Fort Union Subdivision adjudication, and then significant issues and anticipated timeline, and that'll be brief, and we'll turn the time over for questions, which I will oblige and take as long as we need to get through all of your questions, so we'll just stay open as late as we need to tonight. For online viewers, you can send email to Water Rights Adjudication, and I will try and pick up your questions toward the end of the presentation on that email address, waterrights_adjudication@utah.gov. So, to begin with, what a water right is. A water right is a right to divert or take out of its natural course, such as a stream, water, and beneficially use it for some purpose. So the defining elements or characteristics of a water right would be a nature of beneficial use, such as for domestic or irrigation purposes, among many options. A priority date, which is like when the water right was initiated or began. So for most of Utah, they had to come after Utah was settled, so most priority dates are after the 1850s, or 1847. A defined quantity of water allowed for diversion, which is either by a flow rate in second feet, or that's a cubic foot per second, or a volume, which is acre feet. So the volume would be 1 acre of ground inundated with 1 foot of water. That is an acre foot of water. A specified point of diversion, which means where the point, the exact location where the water is taken. If it's from a stream, it would be a head gate or a pump in the stream. If it's a well, then it would be that point defined by a public land survey location and the source. And a specified place of beneficial use, which would be by the public land survey again, which I already mentioned, and we'll get into that a little bit more in detail in a bit. So a water right might be manifested by what you'd see on the ground. You'd see maybe a well or a stream box, a diverting stream box, or a spring collection system, such as these images here. A water right is not shares in an irrigation company or the water that a public water supplier supplies to its customers. So in the cases of that kind of water, it would be that entity, the company, the irrigation company, or the municipality who owns water rights. They own the right to divert water from a well or from a stream, and they serve it to their shareholders or their customers. But if you are the shareholder or the customer, you are not the owner of the water right. You might own your own water rights as a standalone thing, but not in the case of shares in an irrigation company or connection to a public water supplier. as examples. So to kind of tell you why we're doing the adjudication, we like to give a historical context for this. So it's a brief lesson in history a little bit. In July of 1847, the pioneers arrived in the Salt Lake Valley, and they diverted the waters of City Creek Canyon to soften up the soil and used the water, and that's kind of the start of water rights in Utah, those first people who were first in time to take the water out of the natural source. And then they built their shopping mall on top of it. 1848, Brigham Young declared, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." So what that means is that the water rights, or the waters, are owned by the public, and rights are divvied up or given out or allowed to certain holders to use that water, but the water itself is still a public resource. So pioneer settlement went from being part of Mexico to the state of Deseret to the territory of Utah, but government remained church-centric, so it was an ecclesiastical form of government. Diversions of water were generally on a community basis to meet immediate needs of the settlers. The doctrine of priority evolved from ecclesiastical decrees out of recognition of groups who first put water to beneficial uses. And then, the first people that got there got the first right to a water. And then as people settled in later, as people came to settlements, they came with junior priority. So there were primary rights initiated and then secondary rights on the same sources, on stream systems. So conflicts were settled through ecclesiastical channels, such as bishops' courts, and the bishops' courts for wards provided a judicial process that would, with state high councils serving as the appellate courts, they would determine who, and if a conflict arose between water users, the bishops' courts and state high councils would settle the matter and help determine who had the right to use the water in priority, who had first priority, who had next. So the state of Utah became a territory in 1850. 1852, the Territorial Legislative Assembly passed an act authorizing the county court control of all timber, water privileges, or any water course or creek. And Salt Lake County was really the only county to assume these duties. Most of the other counties, streams were diverted without public restriction. So people in Salt Lake County took this statute by the territorial government and exercised it and flexed it, and they made the county court the responsible court for overseeing the water appropriations and water uses. In 1877, the Desert Land Act was passed to promote homesteading, and this act served as it severed the title of the water from the public lands and delegated authority to the states to administer water rights. So the federal government removed itself from water rights administration and said water rights would be under the purview of the states. In 1880, the state legislature, or the territorial legislature, passed an act to replace the county court's authority with some county selectmen as the ex officio water commissioners. It allowed recognition, determination, and recording, but not appropriations. So basically this act, or this 1880 act, allowed county selectmen to kind of enforce and distribute and regulate the water right, or the water distribution and use. But in order to initiate new water rights or appropriate new water rights, that was a different process at that time. So this was only, again, enforced in a few counties. So obviously the process, the legal process or the system that was constructed apparently wasn't in widespread use, and it didn't seem to work very well statewide. So what arose? Confusion arose, and in spite of the efforts of the territorial legislature. And the church continued in a lot of places to administer and decree water rights. So again, the government was largely church-centric. Ecclesiastical decisions would be made to divide the waters. For instance, in the case of the Spanish Fork River, the High Council decision to divide the waters of the Spanish Fork River among some of the canal companies So now we move into where we gained statehood in 1896. So when we entered statehood, the Constitution was drafted with a very brief provision in it stating that all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So the Constitution was very broad, very generic, and it just said, whatever water rights there are, they still are. We're not doing away with water rights now that we're a state. It's just everything that's already been established continues. So that allowed for, well, what happened is in 1897, the Office of the State Engineer was created by the legislature and tasked with conducting hydrographic surveys to measure stream sources and determine what the water rights were. Or the appropriations were generally made by posting notice at the source and at the nearest post office and at the county recorder. But this was largely ignored. So we'll get to when the water rights statute, the all-encompassing water rights statute that was adopted. In order to get there, the Bureau of Reclamation, or the United States Reclamation Service, which later became the Bureau of Reclamation, was established to reclaim arid lands in the western United States. So the Bureau was set up to build big water projects. And in order to do that, the federal government asked states or encouraged states to adopt all-encompassing or comprehensive water rights statutes to provide some clarity or some certainty regarding existing and future water rights appropriations. So in order to secure federal funding, Utah decided that this would be a great idea, and in 1903, we adopted the first comprehensive water law that provided for appropriating surface waters and recording of all existing water rights, which is an important part of why we're here tonight, and the adjudication of rights by the court. However, the legislature failed to provide funding to the local courts for the adjudications, so it didn't happen as fast or as efficiently as was hoped for. And we have, in 1919, so 16 years later, the legislature realized this deficiency, and they directed the state engineer to develop a proposed determination process where it would be proposed to the courts that the water rights should be determined in a specific manner, so as published. So that is called a proposed determination for the court to consider. And then groundwater came under state administrative regulation in 1935. Prior to that, it was more of a kind of a free-for-all. If you wanted to drill a well, go drill a well and use your groundwater, and you didn't have to have anything on the record, and you didn't go through an administrative process to do that. In 1935, the legislature said, okay, there's an issue here of concern, and the groundwater is being withdrawn faster in some places than it can be sustained, and it's affecting surface water rights. And they started to understand that groundwater and surface waters had some interaction and some ties, and decided to bring groundwater under the regulation of the office, the state engineer's office. So here's why we do adjudications. So prior to the enactment of the comprehensive 1903 water law, the rights were typically in 5 kind of categories of rights. There was rights that were decreed by ecclesiastical leaders, claims filed for record at the county, so if they were on the record at the county recorder's office, rights decreed by any kind of court, contracts or agreements among limited parties, and these first 4 are really kind of the written types of water rights that existed. The 5th one is just the unwritten water rights. People were out there exercising their entitlement to take water out of streams or wells or, you know, whatever sources there were, springs, and it was not on the record. So never manifested anywhere, never written anywhere. But as the constitutional provision stated, all rights to the use of water are still in force and effect. They were grandfathered in by the constitutional provision, as we discussed. So even though they weren't written down, they were pre-statutory rights. They were there before the statute was adopted in 1903. So the lack of a definitive water law created a number of issues. There was typically not a public record of existing water rights. It was all scattered around. It was not controlled or combined into one administrative office. Over-appropriation of streams was a real issue because more people wanted water than there was water available. And so it was kind of the first people up on the higher reaches of the streams might get water while the stream was taken dry, and people down lower expecting the water to come to them were seeing nothing. So that's over-appropriation. Rights weren't defined until they came into controversy in many cases. So again, the unwritten rights, the little Dos Equis guy on the right here, people would just assert they had a water right, but nobody knew about it until the neighbor was starting to take the water or the stream was running dry, and then now we have to fight over who has what water right, and well, it's not on the record, so how do we know? And so those would be settled by court decrees. And the state engineer, early on, so again, the state engineer's office was formed in 1897. The comprehensive water law was initiated in 1903. In that 6-year interim, the state engineer made the following observation in his biennial report. He said, the definition of existing rights appears to be of first importance. Why? Because we don't know what all the existing rights are yet. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So, a general stream adjudication is an action in state district court that binds water users and the state engineer. It binds all water users on a given watershed or a given stream system. So all the way up to the upper reaches topographically of a stream system or a watershed. And it's governed by Utah Code, Title 73, Chapter 4. And the first adjudications took place in the 1920s in the Sevier and the Weber, where we have the blue and the green here, and the Virgin River areas. But as you can see, the whole state has color encompassing it, so indicating that there are adjudications that have occurred or are occurring across the whole entire state of Utah. So why we conduct a general adjudication, just getting down to the summary here, is to bring all claims onto the permanent record. You might remember the Dos Equis guy who has a claim, but nobody knows about it. So these are called pre-statutory claims, or maybe more commonly known as diligence claims. If they predate 1903, they're diligence claims for surface waters. For underground waters, they only have to meet that adoption of the underground water statute, which is 1935, and we call those underground water claims. So in the case of pre-statutory claims, to bring them all onto the record. After a general adjudication is closed, that closes out the opportunity for the future filing of claims. So Dos Equis has to participate now or forever be barred in the future. And to define or settle what the Federal Reserve rights are in the various areas. So this is pretty important because we don't want to have the federal government asserting water rights at an unknown quantity at an unknown time and space, which might interfere with existing state-based appropriated water rights. We want to know where entities such as the Forest Services and the national parks and the Bureau of Indian Affairs or BLM, where all these federal entities are using water, and the federal rights are settled through the general adjudication. Which another thing about this is it's sort of unique because these federal rights are settled in the state district court. And that's unique just because the federal government you can't sue the federal government unless they let you. And in 1952, Senator McCarran out of Nevada made a law or passed a bill that helped, wrote a bill and helped it pass that it would be that the federal government must participate if the state serves and makes them, joins them into the general adjudications. Then that's where the federal government must go into the district court to settle their rights in this regard. And number 2 is to prevent a multiplicity of suits. So rather than just having a small number of parties, or 2 people, or just a localized suit between people trying to settle, well, I get the stream, no, you get the stream, okay, well, let's split it up. We consider all of the people on the stream above and below the limited parties so that everybody's rights can be well defined and so that it's not just a single suit and a bunch of pockmarked single suits dotting the land. We just consider all the water rights all in one because they interplay. Water rights, again, have a priority, and the first in time is the first to get their water right. First in time is first in right. And there may be right holders upstream or downstream of any given water right, and in order to fully adjudicate the interplay of those water rights, the general adjudication joins all the parties. And this last one might be the more controversial one, but it is to remove or reduce the rights that have been wholly or partially abandoned or forfeited through non-use. So over the last 121 years that the State Engineer's Office has been in, or the 122 years that we've been a state, it's been 122 years. A lot of people or a lot of water right holders have ceased using their water right or stopped exercising that right. And those who have stopped exercising that right, for that, there is a provision in statute that requires or that provides that a water right must be used or exercised within 7 years, or at least once in 7 years. So if it isn't exercised in 7 years, if there's a time span, a block of time where the water right goes unused, then it can be subject to forfeiture, and the general adjudication will have that water right declared by the court to be forfeited. And number 4, to obtain a final comprehensive decree on all the water rights within the respective drainage. So this basically summarizes and explains or lays out what all the water rights are in any given stream system. I feel like I've been rambling on too long. If you have questions, feel free to pipe up or raise your hand, and we can address your questions if they pertain to the group. And we'll just entertain your questions if you need. Yes, sir.
How far back can you determine if a 7-year period of the water right was not used? How back how many years?
That's a good question. The gentleman says, how far back can we determine if a water right has not been used for a period of 7 years? And the answer to that is within the last 15 years. Within the last 15 years, if there is a period of time that for 7 years the water right went unused, then it can be subject to forfeiture within the last 15 years, ending within the last 15 years. Yes, sir.
Actually, I have 2 things. One is, does this have anything to do with sump pumps? You have water, overabundance of water in your house. And the other thing is, if it turns out the water, if there's some sort of pollution or contaminant issue, how does that factor into the rights?
Okay, let me ask for clarification. So on the one, on the first part of your question, are you wondering about sump pumps? Is that what I heard you say?
Yeah.
Okay, so the question was, does this have anything to do with sump pumps? And does it have anything to do with water quality, if in a nutshell? And the answer to that is yes on the first one. To use water out of a sump pump, which would be considered a source of water, whether it's shallow underground water or shallow, water at the surface, it has to do with that. And so in order to use water from a sump pump, there would have to be a water right in place. And for part 2, water quality is not under the purview of the state engineer's office, and so quality concerns are not addressed by water rights. Water rights is more regarding the allocation and quantification and definition of how the water is being used. Yes, sir.
So, 15-year thing this gentleman asked about before, so the land was the house was previously owned. I've owned it for now 5 years, 6 years, whatever. If that 7-year period hadn't been used before that, would I forfeit by changing?
Okay, so this question is, I bought a house about 6 years ago, and if there was a period when the prior owner of my house didn't use the water for 7 years within the last 15 years, does that carry into my ownership, or does that apply to me? And the answer is yes. So it doesn't, so maybe to change the way to say that, the ownership of the water right is not part of the consideration of looking just at the water right. Has the water right been in use or has it not? Does that help?
So you would be able to tell if he had used it before.
So that consideration or evaluation should play into evaluating a water right or its claim, the claim on the water right. So we should be able to, try to look into whether the water right has been used. So, but let me just tell you that we'll use what tools we have available to us, and we're not going to get down into nitty-gritty CSI style investigating, well, isn't there a period when your prior homeowner didn't use the water? If you've placed the water to use and you're using it, I think we probably would take that for bona fide use and just drive on and not really be too worried about it. I saw one at the very back of the room, and then I'll come right to you.
I think it needs clarification at this point as to whether we're talking about private use or company or corporate uses by such things as such people as ditch companies.
Very good. Okay. So he's wondering if we're talking about just private use of water or if we're talking about the shareholders' use through a ditch company. And the answer to that is, in a way, we're talking about ditch companies' water rights because we are talking about all water rights. And so if you're affiliated with a company, what I urge you to do is make sure that your company is participating in this adjudication process. As to private rights, that's mainly what the focus is on, but the focus is on all water rights.
So if I'm hearing you right, a company that's registered as a ditch company, for instance, of course, their interest is in this. They will have followed this appropriately, and so then the issue is not whether we as a shareholder in the ditch company, but rather whether we're using outside of that ditch company if they're doing their due diligence.
Yes, so very good. So for clarification, and I appreciate your comments, it is the ditch company or the company that is incorporated to hold the water rights that is responsible to participate in the adjudication and make sure they file claims on their water right or portfolio of rights. And in the case of shareholders, if you are a shareholder in a company and the company is the owner of the water rights, then as to your shares of water in that company, you don't have to be the person that files the claim. It is your company that should be responsible. Nevertheless, I would encourage you to make sure the company is responsible and doing it. And then separately, if you have water rights apart from your company, if you have a well, or if you have a right that is your own personal, ownership, your own water right, then you need to be proactive about participating in the adjudication as it regards that water right. Okay, and this gentleman?
Well, mine's related. I'm a shareholder in a particular company, and they've used the water. I have not personally used the water. I'm worried about the 7-year thing. The second aspect of my question is that the water company sold out to the city of Salt Lake. And the city of Salt Lake in this lawsuit?
Okay, good questions. Very good. So two-part question. This gentleman asks that the company that I have a share in has been using the water. I might not have been exercising my share or using my portion of the water. And so that's his first part question. And the answer to that is a shareholder's portion of water can be subject to a forfeiture if it hasn't been used or diverted and beneficially used. And so in the case of a company who has, let's say, a bunch of shareholders and there's a section or a portion of shareholders, there's a class of shareholders or a handful of shareholders that haven't been using their water rights, or that the company has not been diverting and using the water for those shares, that portion, so it may be subject to a partial forfeiture. So the company's water rights might be defined as a diminished amount of water for the use that has been occurring. And so that's the unfortunate part about that to the shareholder. But again, unfortunate is subjective because the law is the law and it's set up to protect all the water users. And so the second part of that is municipal rights. And there is a provision in statute that municipalities are immune from forfeiture actions given certain provisions. And in the case of probably what's applicable to your company's water right, if your company has, if the company's rights have been acquired by Salt Lake City, which is kind of how I think I heard you say it, Salt Lake City, the city is immune from a forfeiture action if they acquired that water right prior to 2008. Now, of course, I'm telling you about statute, so what I'm really doing is I'm kind of interpreting statute, and it's probably a good thing, or maybe it's a bad thing that my attorneys aren't here tonight. So the AG's office is kind of absent at the moment. Okay, I will move on to, let's get maybe let's get 4 more questions. This one, that one, that one, and that one, okay? Yes?
Under the general adjudication, is there anything that monitors appropriate use?
So under general adjudication, is there anything that monitors appropriate use? And I guess you had the air quotes around appropriate use. So the answer to that is beneficial uses are, there's a broad range or a wide variety of beneficial use types. There's irrigation, there's domestic, there's livestock watering, mining, municipal, commercial use, and other uses. And it's beneficial if it's being diverted and placed to a use that falls under that umbrella. And the umbrella included another category. I don't know if you're getting at a specific use that you have in mind, but or if you want to clarify.
Sometimes there's overuse. There are certain rights that people have around us.
Okay.
Overuse is called excess.
Excess water or overuse, or it looks like people are taking too much water and it goes to waste. That's a good point. So there is a provision that allows the state engineer, I'm trying to think if it's a statutory provision that allows the state engineer to set a duty governing what is beneficial, and anything more than that is wasteful. So in Salt Lake County, and I think it's determined through the adjudication, the general stream adjudication process, in which the state engineer proposes to the court, and the court can, and the state engineer can propose to the court what that duty would be. In Salt Lake County, for the most part, the duty is 5 feet of water. So it's per year. So for irrigation. For irrigation, 5 acre-feet to the acre, which means you can water your lawns, 5 feet through the season. It's hard to, I guess it's hard to explain, but it's 5 acre-feet to the acre is what it is in Salt Lake County. The person in the back, and then this one, then that one.
How do you determine, like we're part of a ditch company, we're a shareholder, how do you determine which shareholder is using it or not? I mean, we don't have meters on it. How on earth did you determine that?
All right, that's a good question. So how do you determine what shareholders are using their water and what shareholders are not? The answer, I think, lies in the administration of the company and the company's claim and the investigation that is borne out through the claims evaluation process. So a company would have a set definition of their water rights. It might be a water right that is to divert all of a stream, all of the Big Cottonwood Canyon Creek, and send it up through their canal and use it on 1,000 acres of land. And if the company can only show that the water right is being used for 600 acres of land, and we can't, or they can't show, or we can't see where the other 400 acres are, then those other 400 acres, that the water right designated for the other 400 acres would be potentially subject to forfeiture.
Okay, follow up on that.
Yes.
So there's 1,000 acres and you've got 20 different shareholders. How do you know who's 400 back up?
So that is a company matter. So that is a matter between the company and its shareholders. So good, thank you for the point. So repeating the question. So the question is, as a follow-up, if 400 acres of the company's 1,000-acre water right gets forfeited, how do we know which shareholders suffer that reduction? And the answer is The state doesn't administer that. The company administers its shares, and if it needs to do its bookkeeping and go through its tabulation of shareholders and determine whose shares are individually accountable or responsible for the reduction or the forfeiture, then they can, and the statute provides that they charge that against those shareholders, or those shareholders' shares may be, I'm trying to think of what the word is, just reduced or taken away or surrendered or invalidated. I don't know what the proper terminology is, and corporate governance is not my specialty.
I'm still having trouble with it without meters, because none of them are meters that I know of.
So,
They meter it?
so she asks, how do they determine if it's not metered? And the answer that I would provide is water rights are most specifically defined by their beneficial use, which, as a clarifying factor here, the beneficial use is the land that it's being used on. And so we would look at and find the 600 acres. So whether you're using the full 5 acre-foot duty, which I answered to in the last question, or whether you're using 1 acre-foot to the acre, is a little bit immaterial about whether you're irrigating that land. So if you're irrigating the 600 acres, then that is what counts. And the shareholders that have those 600 acres are the shareholders that are protected. And again, that is less of a state engineer matter and more of a corporate governance matter. We'll get to this one and then finally this one.
Thank you. I belong to a residential HOA, condominium, townhome complex. Each of the owners received a letter. Going forward, does each of the owners need to respond to this by themselves, or can the HOA represent all the members of the HOA collectively?
That's a very good question, to which I'm not going to be the expert to answer, but the question is, I belong to an HOA, and all of our members, or everybody that owns property here, received one of these letters. Can the HOA speak for all of us or be the representative to participate in this action? And the answer to that is it depends. Depends on whether the HOA is the owner of the water rights that are at the matter, the water rights that are in question, or whether each of the individual property owners remains the owner of the water rights. So again, that's probably a better question to ask legal counsel, or maybe somebody who can do your title searching and figure out who's the owner of your water rights.
Thank you.
And finally this.
Yes, my son and I have water rights, and we have an acre of ground between the two of us. And we got our water through a company called the Brown and Sanford Irrigation Company. Now, we've lived in this house for about 54 years, I think. And during that time, they came in and built subdivisions all around us. And so they didn't want the open ditch anymore. So the city said, we will trade you water through your culinary, you'll get it through your pipes, rather than through the ditch. And so we have water shares, and my son has water shares. And we've been doing this for some 15 years now, or maybe 20 years or longer. And we're wondering if there's gonna be any change to that. We have water shares, and we're using the water, but we have been getting it through the
Okay.
pipes now.
Okay, I appreciate the question. So the question is, we had shares in Brown and Sanford, and the city came in and piped the ditch and offered to exchange the shares for water service. So the city serves them water through the city's connection, the pipes. And will there be change to that arrangement? The answer is no, not through this state, not through this adjudication process through the state. So your arrangement between you as a shareholder and your company, the Brown and Sanford Ditch, and Salt Lake City, the city, has very little to do with the state's general adjudication of water rights, but I can certainly assure you that Salt Lake City will participate in the general adjudication and file claims on any rights it owns, and you might encourage your company, if it has director or president or a water master or somebody that represents the company, you might encourage them to be sure to be participating in this adjudication effort. I hope does that fairly well answer your question? So yes, the adjudication won't change physical aspects about how you're getting your water. It's quite much more of a paperwork, bookkeeping, claims. People file claims, we evaluate and process claims, and we publish a book to the courts, and the courts enter a decree. Quite much more paperwork and less physical changes.
And then there was a number of people all around our neighborhood that each have, we got 2 shares of water, we got 3 shares, we got 4 shares, we got 1 share, and so on and so on. So instead of Brown and Sanford having a ditch to take these waters through different people's property and so on, why it all comes through the.
So this is the case for many of your neighbors. Many of your neighbors have been able to exchange their Brown and Sanford into service from Salt Lake City. They'll be in a similar situation as you, and I don't know if that.
Ditch has been covered over now, and it makes a good storm sewer, so it goes through the school and through the neighborhood. Any rainwater, anything goes into where the irrigation used to be, and it's a works out this really fine.
Very good. Okay, so that about sums up. Yes, sir.
And that is, we're scheduled till
7 o'clock.
I'd like to have
Yes.
some clarification yet for the record, and that is, are we not here to appropriate water from unauthorized and unused shareholders? Or
The answer to that is no. So the adjudication is not intending to be the forum that other shareholders can appropriate or take over. Okay, go ahead.
who started the action?
Good question. So let's move on to this adjudication process. So in this case, in the Utah Lake and Jordan River General Stream Adjudication, the action was started in 1944. I'll just see if I can get to that right here. There, I'm missing something. So, sorry. The petition, the action that we're dealing with tonight was started in, well, really the 30s, but then it was broadened in the 40s. So 1944, Salt Lake City versus a bunch of water users filed in the courts in order to try and settle the rights to the use of the Jordan River. And the court broadened it and said, well, it's not just the Jordan River, that reaches up into the Utah Lake, and that reaches up into the Provo River, and the court broadened it to the whole Utah Lake and Jordan River drainage, which encompasses parts of Wasatch, parts of Juab, all of Utah, most of Utah County, Salt Lake County, etc. So 1944, it was started by a petition that got broadened by the courts to the general adjudication. That's right. So here we are in 2018, and it's finally Fort Union Subdivision's turn. Last month, it was Sandy Midvale. 2 months ago, it was East Murray. 3 months ago, it was West Murray. And we've just progressed month by month down the Salt Lake Valley. Then later we'll go down Utah County. But over the years, we haven't gotten to the bottom of this issue. So it's been taking a long time to get to. So moving on, notice is given in the newspapers and summons in a public meeting, which you received, which we're doing. And then what we'll do next is in the coming 2 weeks, we'll send out notice to file claims. So it will be everybody's turn, especially those who are in the camp with Dos Equis who's never filed a claim, but also everybody who has a water right of record, whether it was through an appropriations process or if it's a decreed water right or whatever kind of water right you have, everybody whether it's of record or not of record, needs to file a claim. And then if you don't file a claim, yes, sir?
So if the claims are already recorded and on file, we still have to refile that?
That's right. If your water right is already on the state engineer's records, then through the adjudication process, you must file a water user's claim that is current today, unless you already had a water user's claim in the general adjudication. So it will be captioned with the court case number, the civil number. And if you don't have a claim that is captioned with that case header or that case name in the matter of the general adjudication, if you don't already have a paper claim that has that caption on it, then you'll have to do that in order to assert your water right in this action. Okay? And for those rights that are of record that don't have a claim filed on them, they will get published on this list of unclaimed rights. So they'll be unclaimed. And then if your right happens to be on that list, then you'll have 90 days to object at the court, file an objection with the court, stating why you missed the claims taking period and why you should be allowed to file late.
Just to clarify, where will that list of unclaimed rights be posted?
Good question. So the state engineer's office will have the list published. It'll be available at our office. It'll also be published online, and so it'll be available through the Water Rights website, waterrights.utah.gov, and we will mail notice to all the same people that got the mailing for this meeting. So presumably, if you're getting your mail and you got the mail for this meeting, you should be able to get the mail that we send out for the list of unclaimed rights. So that list will end up being published several months down the road from now, many months, probably 4, 5. Yes, sir. Yes, so the adjudication will happen in drainages throughout the whole state. If you recall the colorful picture of Utah, each one of those is one of the adjudications happening in Utah. I don't know if you missed that. It's on the slideshow earlier. So the whole state will be adjudicated. As to this adjudication, the Utah Lake and Jordan River, it's a piece, and it's unrelated to the other rivers in the state, and the timelines are unrelated, and the other parts of the state, especially if you have interest in properties or interest in water rights in other parts of the state. Okay, Wasatch County is more likely part of this. Wasatch County is a part of the Utah Lake and Jordan River adjudication because the Provo River comes down through there. But at this moment, we're dealing with the Fort Union Subdivision, and at a later time, we will get into subdivisions for Heber or Wasatch County. So, thank you. Then we publish the list of unclaimed rights, and after 90 days, we can, a person has 90 days to object to the list of unclaimed rights if they object. Also, in that period, we hold a public meeting to explain the list of unclaimed rights. You're welcome to come to it too. It's quite simple. If your water right of record is on the list, then you probably don't want it on the list if you're exercising it and you need to file a claim. Don't take my advice as legal advice because I'm not an attorney. Objection, resolution, and decree, and that's just the part about claims taking and claims filing and the list of unclaimed rights. We get a decree on the list stating that these rights on the list have been abandoned. Then all the claims that are filed or that are asserted by claimants to be water rights or valid rights, we investigate them, and we make a proposed determination to the court. So I mentioned proposed determination earlier on tonight, which is the description of water rights given to the court in order to finally determine and adjudicate all the rights. There would be a 90-day objection period after it with a public meeting in the interim. We would publish a final summons in order to get an all-encompassing notice out to people that this is happening and this is just about over, and then the court can issue a decree after all objections are resolved. Yes, sir?
So your definition of water rights says
So the question is, who defines or decides what beneficial use, or is any one beneficial use more beneficial than another? And the answer to that is no. The water rights, in the most part, or for most respect, the answer is no. The right to use a water right is a standalone thing with a defined nature of beneficial use, and what governs that use is its priority. And you can exercise it whether it's a right to irrigate pasture or whether it's a right for 10 homes. Another person cannot force you to use your water right to grow homes or to raise the homes and make pasture again. It's just they're standalone things.
The reason why I asked that is it would seem like there's a little bit of a conflict, because I would think the cities or the municipalities would rather see tax base rather than somebody having an acre of water or a pond. Is there going to be any disagreement over how that beneficial use is decided at that point?
So is there any disagreement over how a beneficial use is decided from the state engineer's perspective or the office of the state engineer and the Division of Water Rights? No. So as to how a city operates, I don't know. But as to state law, a beneficial use is given for a water right, or the water right has its defined attributes of its beneficial use, and that is particular and special to that water right and can't be forfeited or taken away, or you can't be strong-armed into changing that use, not by the state engineer or by the court.
So, 4 years ago, I moved into this house, and over the years, I realized that everyone around us has water rights except us. The creek basically runs almost through my yard under the street. And when I got this letter, I'm like, maybe that's not true, because when you talk to neighbors, they all say, well, you didn't have one before, you can't get one now, and, the previous owner should have sold it to you. Does this mean maybe they're not right? I might have a right?
Okay, so the lady says, I live amongst a bunch of neighbors who have water rights on the creek that runs right through my property, and the question is, do I maybe have a water right? And the answer to that, I think I would encourage you to research the situation further to determine whether the prior property owners of your piece of property had a water right, whether you can ferret that out from existing records, and you may have to research, existing water right records. You may have to research deeds from your property, and whether you had a water right on your property is, well, I guess now or never is a good time to figure that out, because the general adjudication effort will eventually publish all the existing current water rights, which forecloses reestablishment or resurrection of any other unknowns.
So there's a way, so you know if I have a right or not, I'm just not using it, or?
So she asks, do we know if I have a right and I'm just not using it? The best way to get at that question, I guess, would be if there is a water right of record for your geographic area. So the water right records that we have in, the state engineer's office has the records of existing water rights that are on the record. And if that is something that we have that points to your property location and the stream that runs through your property, and it indicates, for instance, that maybe a specific person by name had a water right on that creek, and you can tie the ownership of your property today through a chain of title back to the same person who owned a water right back in that day. So if your property was once owned by the same guy who is on our records as having a water right, then you might be able to make that association and figure out that there is or was a water right on your property.
I'm going to have to prove that. That's not something that you will determine.
So what we will determine is those who file claims, those claims will be investigated. If you don't file a claim, then we'll have nothing to go off, and any potential claim that you may have had would be foreclosed.
So you suggest a false claim.
Yes, you can file a claim and we'll investigate it. So we'll help, so
Based on information from your property title,
so I'm gonna,
location.
I'm just gonna, I don't know if that wasn't exactly clear. I'm guessing that wasn't exactly clear by the look on your face. So maybe we can talk after the meeting is over tonight. Okay, thank you. All right. I think I'm just going to go ahead and move on, and maybe we can get at your question in a little bit, okay? So filing your claim, we will send out shortly, in a couple weeks here, a notice that it's time to file. It'll be published in the newspapers, and we'll send with it a claim form. So if it is a water right that's on our records, it will be generated out of our water rights database, and it'll have information filled in on the claim form stating where the point of diversion is, the place of use, the beneficial use. If we don't have a claim, then in the mail you'll get a blank claim form saying that if you do have a claim, if you're in the Dos Equis camp, then now's the time to file. You can file your water user's claim with our office, or the hard way would be with the district court. You're welcome to file there. And we will do our field investigation and map your use. The investigation forms the basis of the state engineer's recommendation to the district court. Again, that recommendation is the proposed determination. The list of unclaimed rights, again,
On the field investigation, does that mean you physically go out to each of the properties and investigate claims?
yes. Our claims evaluation teams, so we have a couple team leaders in the room in the back here and the back over here, standing and sitting. They will be out on the ground. They'll be in contact with you by phone or however they can contact you on your claims. And they'll try to set up an appointment with you to evaluate it. If they can't reach you, then we will attempt to just go out and evaluate it without an appointment. So either way, we will make an effort to go out in the field and evaluate your claims. The list of unclaimed rights of record gets published. I think I went over this in a fair amount of detail already. So objection resolution, if people object to the list and state, well, wait, I had a water right and here is my claim, then we resolve those objections and we seek a judicial decree on that list, declaring the rights on that list have been abandoned. Yes, sir.
The previous areas that have been through this, that have gone through the 90-day, the 90-day, the 9-day, has it gone smoothly, has it been cleared up, or is this thing just gonna drag out for who knows how long, because it's just not working out?
So the process to me seems pretty smooth. I guess that's a subjective, opinion kind of question. And ma'am, have we, let's get to your question if you can recall it.
I'm just wondering what happens to these if there are rights that are unclaimed.
So rights that are unclaimed, yes, rights that are unclaimed do go on the list of unclaimed rights. Rights that are not of record, they're just out there and people don't know about them, but somebody is trying to exercise it or somebody potentially would have a claim. If they don't get claimed, then the judicial decree forecloses or bars. It prohibits, by this last little sentence on the page, prohibits future diligence claims from being filed. So that is the disposition of all potential claims and claims for rights of record. So hopefully that solves that question. then we publish the proposed determination, which water users' claims that are filed will be investigated and mapped. A public meeting will be held once the proposed determination has been published and filed at the court. In the case of this adjudication, we intend to have and in answer to your question over here, we intend to have the proposed determination prepared by about February 2020, roughly, give or take. So the 90 days after this coming notice to file claims, the notice to file claims is coming in the next couple of weeks, then 90 days. And then we will publish the list of unclaimed rights, then 90 days. So that's so 6 months down the road, we might get the judicial decree on going backward the list of unclaimed rights, 6 or 7 or 8 months down the road. And then going forward, we would publish the proposed determination in a year and a half from now. So claimants would have 90 days to file an objection with that proposed determination with the court. Objections have to be filed at the court, so I want to just drive home that point. Whether that's important to you, it's important to me. Objections must be filed at the court. You can give the state engineer your objection, here you go, state engineer, but you have to file it at the court. Objection resolution, and then a judicial decree on the proposed determination. So, just getting through, we are almost done, just for those of you that are getting antsy, and you're welcome to leave. There's no requirement to be here tonight. Yes?
At the end of this final process in February 2020, do you issue a certificate? Is there something there, or is it just on file?
It would be just the proposed determination. So in 2020, when we get to that point, we don't issue individual water users a new certificate. We don't do any new thing other than the proposed determination will be the compilation, the compiled report of all the water rights, and each individual water right would be described with its attributes, line by line, a point of diversion, a place of use, what it is being used for, a priority date, and so forth. And each of those water rights, so a proposed determination can be lengthy. We published one recently that was over 500 pages long, but each of the water rights is in there, so one by one. So your water right is in the PD. And that is the end of that. So it's not a new certificate, it's just the PD book, proposed determination book.
Okay, and we could go in, would that be online?
So that PD book will be online when we publish it, and we will also send notice to all water users who filed a claim or participated in the adjudication or were joined in the court process in the civil case. All water users and all joined parties will get notice of the proposed determination publication. Okay, so here we are. This is where we are tonight. It's the Fort Union area, and I think a gentleman asked about, are we doing this across the whole state? And the answer again is, right now we're focused on the Utah Lake and Jordan River adjudication, which is quite broad. Utah County, Wasatch County, Salt Lake County, and parts of other counties. And we take it in bite-sized chunks, so we can't do the whole entire from Salt Lake County through Utah County through Wasatch County all at once. We do one subdivision at a time. So it's not a subdivision like a neighborhood subdivision with a street and 10 homes, but it's a subdivision of this broad general adjudication. It has about 10,000 homes or properties. This is the number of people, 9,139 that got notice of this tonight, and it looks like we had maybe 3 dozen show up, which is fine. It's there's only probably about 1% of the people that got this notice that may really have, that 1 to 2% of people that really will have a valid claim to file in this case. Yes, sir.
I own a small piece of property that has a well on it, and it's been capped for years. How do I go about finding out if there is or was ever a right on that property?
Okay, so on your property, there's been a well capped for several years. How do you go about finding out if there's a right on that property? Very good question. All of these pink dots, they all indicate the location of a water right point of diversion. And so if it's on the, if your property's well is on our records, then you could, and maybe the easy way is to get on our map server system on the internet. So we have a geographic information system, a map that you can find if there's a point on your property. We also will have the large maps out here tonight, and we also can surf the web at the end of the meeting. So if you think you have a water right on your property, it may very well, if it's already on the records, it may very well be represented by one of the points on the map. So issues and anticipated timeline. So one of the issues that people run into is there could be title or ownership that is like from 80 years ago. And that is just a fact of life. That's what the record says. So we have a file room upstairs, you know, full of water right files that a lot of these, or most of them, were established or initiated decades ago. And nobody has ever provided the state engineer with the proper documentation, the deeds showing that the water right transferred from person A to person B to person C to you. And so that chain to you is lacking, but it doesn't mean that you're not the water right owner necessarily. It just means that you are not showing as the water right owner on our records. Ownership is an issue that is settled by deeds. So deeds are the way that water rights are conveyed from one owner to another, and those deeds must be, and so are, recorded at the county recorder's office. And so if you think you have ownership of a water right, you would have to do title search of deeds recorded at the county recorder's office. One more thing about ownership is that water rights generally transfer by appurtenance, meaning they belong on the land or they pertain to the land. Appurtenance and pertain are not necessarily the same word, but that the water right belongs with the land and it transfers with the land silently by deed unless the deed explicitly reserves it or a prior deed has conveyed it away. So if your chain of title, going back to the person who owned the property before you and so on back to the person who owned the water right and who is showing on the state engineer's records, on our records, if that chain of title, those deeds in the county recorder's system are silent, it is still likely the water right transferred from person A to B to C to you. Possible.
So what you're saying is great and a little intimidated to a layman like me. So I think what you also said is that I can simply file these rights and let you do the work.
That's a good question. So he's wondering and says, if what I'm saying is that I have to do the work and file my claim, can't I just file my claim and it's really simple and then the state engineer will do the work? So the answer to that is not really. The state engineer will investigate your claim as to its contents. So your claim, you want to make your claim as robust as you can make it. You want to include as much information regarding the establishment and exercise of your water right as you can. So if you are just throwing a piece of paper at the state engineer's door saying, here's my claim, and the state engineer sees no basis for the water right, there's nothing on our records indicating that somebody appropriated it originally or that there's a decree from the 1800s or that there's a reason for your water right, and we can't figure out that it's pre-statutory, that it came before 1903 in the case of surface waters or 1935 in the case of underground waters, then we would not likely have much of a basis to go on to recommend that be validated or recognized in this process. I hope that did that justice. I just keep looking back at the state engineer to see if he wants to correct anything I'm saying, and he's giving me the thumbs up and the smile and the nod, and I'm like, okay, whatever, I guess this is all good information. So, the other issue, location of no proof required water rights. So in the case of many applications that came to the state engineer's office through the proper channel after statute was adopted. statute was adopted again in 1903 and revised again in 1935. It's been revised lots of times, of course, but the big parts of the statute require a person to file an application with the state engineer to initiate a water right after the statutory adoption date. And in many instances, the state engineer had a process that said, okay, file your application, and that was the end of that process. There was not a proof required showing that the water right was developed or properly put into use and continues to be exercised. Those no proof required water rights, they are questionable sometimes as to their location because the application was filed and it specified that the well was going to be over here on this 40. The farm had 160 acres and the well was going to be here. And then the farmer went and drilled the well elsewhere, and we don't know about it, and there was never paperwork brought onto the record to show where it was drilled, and so the location of that might be lost to common knowledge. Or the location, you may know of your well, and you may be using that well, but the location of the water right of record for it might be off, and despite all the fancy tools and the map server and all of the ways that we can search for it, we still may be unable to find the record for your well. So that could be a hiccup. So again, I think we did most of the timeline. Notice to submit claims is coming to you in a couple weeks. On June 29th is going to be the date we anticipate. That gives you 90 days till September 27th for this claims filing process. Publishing the list of unclaimed rights is anticipated in January. Of course, we don't have a day set for it, and we don't have a day set for the future events, but February, the proposed determination, 90 days after that, the objection period would end, and then we would be seeking a judicial decree on this portion, on this subdivision after that. And then after we're done with the Utah Lake and Jordan River general adjudication, which may be quite a bit into the future, given that it's already been since 1944, I don't know how long into the future, but not too long, we would seek a judicial decree on the whole Utah Lake and Jordan River. Will I lose my water right? Maybe this slide would have been better to have earlier on in the presentation, but it's water users who are currently using their water right. As long as you file a water user's claim, so as long as you file your claim, have nothing to worry about. Individuals without a water right of record, the gentleman already left, but you must file a claim, and I urge you to include as much information about it as you can, rather than just a shallow framework of, well, here's my water right. Hopefully the state engineer investigates it and validates it. If the water use authorized has fallen out of use for 7 years or more, the state engineer's office would recommend it or a portion of it to be disallowed and seek that the court rule on it as forfeited. So it's kind of that would be the issue with a water right that has no claim on it or has no use on it. We would recommend the court, we would recommend it be disallowed. We would seek the court to declare it forfeited.
So we received the water right a little over 2 years ago, and we've been working on it, put a vault over it, ran electricity, things like that, but we're getting the pump for it. So we're 2 years into our 7-year period. How do we provide proof of beneficial use when we haven't been able to finalize everything?
Okay.
Moving towards that.
So you are, and so it depends. So I almost gathered from some of the content of your question, and the question is, I'm working toward placing my water to use. I'm making efforts. I've done some developments. I just haven't placed it to use yet. And the answer to that is, it almost sounds like you have done an application at the state engineer's office. Is that the case?
No, we
You have the water right. It's on the record. And so there's probably an active application. If that's the case, then there would be pending proof due date in which the active application has to have you file proof on prior to the due date or get an extension. And if that's the case, you have nothing to worry about if you are actively pursuing that on an active application. Now, an application can be built on, so it can be a change application on an existing water right. I don't know your case, but you may have an existing water right that is located elsewhere, and you've filed an application for a change application to move it to your property. It's a well, okay. So we may need to just discuss your case with one of our team leaders, or you can ask me after this is over. Okay. Thanks, and I think that pretty much concludes the presentation tonight. So my supervisor is Blake Bingham. He couldn't make it tonight, so he gave me the reins. And I'm Gary Brimley, the adjudication engineer. John Bream is the team leader for this subdivision, for Fort Union Subdivision. And these are our contact information and the Division of Water Rights contact information. Again, that email address, let's see if I got any emails in. It was waterrights_adjudication at utah.gov, and I'm not seeing that any emails came in through that email address. We did stream this meeting live to the YouTube, but no emails came in, so that concludes our meeting. If you want to stick around, we can search for your water rights on our map server. I can also demonstrate the website if we have a consensus that that would be a good thing to do right now. Okay? Yeah. Yes. So here's our contacts.
It's on the sheet they handed out too.
It is on that sheet,
Yeah, it's on the sheet. Oh, yeah.
so you can pick up a sheet. So do we want to look at the website briefly?
Yeah, yeah, for sure.
So we go to water rights. Waterrights.utah.gov is the web address. And it brings you to our homepage like this. It's quite busy because there's a lot of information, and it's tailored to a lot of characteristics and attributes, a lot of things in water rights. So for instance, water rights, dam safety, stream alteration, canals, distribution, enforcement, adjudication. So I would go to adjudication, maybe, depending on where you want to go. So here, if I click on adjudication, here's active adjudications is under this button, and Fort Union Subdivision is probably toward the bottom of the page. Actually, it's covered up by the banner at the bottom. Unfortunately, we'll have to get our programmers to fix that. I've been intending to. Map search. So if you're looking for a water right on your property, you may search by your property address. So if I go down to property address under this search tab, and do you want to do your property? Your mailing or your property address. Or somebody give me a property address. 8231 South 10th East, Salt Lake City. Sandy, Salt Lake County. So does that probably look like it with a street to the north there? Okay. With the red car driving on the street and the other car. So if I could, I don't know about the ability to use this. It's not, there we go. That's how. So in this neighborhood, in this vicinity, at this property address, it looks like we have a well in the street over here. The location of the tags is not always perfectly accurate. It can be off by several feet. It could be off by hundreds of feet. Who knows?
There is a well in the back corner of
So there should be a well on the back corner of the lot somewhere in here.
southeast side,
Okay. And so, what I might do is, under points of diversion, I have to turn on all points of diversion, so everything is coming up. And then we'll see if that added any points, which it didn't. So the closest thing to the vicinity of what we're looking for here might be this well, which is a Jordan Valley Water Conservancy District application, standing unapproved as of yet on the records. Then the next closest would be these points. Jordan Valley owns some water rights in this area, apparently. And the next closest thing of record is a gentleman's domestic and livestock watering water right for quite a small amount of water, 0.015 CFS. Of course, learning what all this terminology means is not necessarily something you'll do in the matter of an hour, but that's a small water right that is showing of record in that place. So if you think that there should be a water right, we just don't know about it, then you may have to file your water right claim on that unknown water right. It's a water right that's not of record, or it may be a water right and it's just not of record. The investigation or the claim that you use, what you put in as the basis of your claim goes into that investigation, right? So if it's a well that's been there since prior to 1935, then it may be you have a valid claim. If it's not, then you may have an illegal well. And so I'm not here to determine that right now.
and what happens if that's the case?
So if that's the case, so if it's an illegal well, then through the adjudication process, I like to keep it in the box that is adjudication. If there's not a claim, or if there's not a valid water right for it, if you filed a claim, if our investigation doesn't bear out a validated water right, we recommend that it be disallowed to the court, and the court would declare it invalid. And then that's just the adjudication box. It's, again, a paperwork process. The ramifications of it are another matter, right? So separate from adjudication, you would be using water from an illegal well, and that may be subject to enforcement, which may be subject to heavy, extensive fines levied.
I could actually be in trouble for something someone that owned that property previously for might have done the well.
You could, I suppose, if you continue using the water, that might be a bad thing. Yeah.
Did every resident in this area receive a letter, or only those people with proposed water rights?
No. So yes. So every residence is included, and we sent notice out to everybody because our intent is to capture all potential claimants.
Cover the bases.
And everybody's potentially a claimant, or everybody is a potential claimant because we don't know if you have a water right or not. So from our perspective, we are doing due process. We're doing due process to help everybody have that opportunity. Okay, I want to address this lady's question. Do you have another question? Okay.
Travis address.
Yes.
810 East Ponderosa Drive.
So this look kind of like it. The second house in from a street over here on the east.
Okay, it is between the X and the 1.
Ah, yes.
Right on the right-hand side there is a small piece of property between those two houses.
Mm-hmm.
That has a well.
Okay.
I own the house on the left, and right there, you can see that little box, where you're at right there, it's inside that little box.
Very good. Okay. So that's its address right there. And the closest thing I have indicating anything in the vicinity is this this tag here. So this tag here says water right number 57-2471. I would latch onto that if I were you and investigate it. Doesn't, you know, just this cursory review doesn't necessarily mean it's your water right, but it very well may be. Go ahead.
Just was gonna ask for another address.
Okay.
784 Rain Tree.
Rain tree, like rain tree. And that's a street or just rain tree? Okay. And does your question have to do with a map or just concepts?
Just concept. So, question is, during this claims adjudication process, so there's a water right on our property. We had 2 lots that were subdivided since the water right was recorded. So if we want to just update data on the recorded water right, can we do that outside of this adjudication process?
Yes, so what you can update, there's methods and there's administrative processes to update data. Thank you. Thank you very much. So I guess the question is, you want to maybe update the water rights characteristics or its ownership?
It's ownership.
Its ownership. So the process to update water right ownership is called report of conveyance. And with a report of conveyance, you provide the state engineer on the form that the state engineer provides that's called a report of conveyance form, that's its caption, report of conveyance, and you provide the information about your chain of title, the deeds, you know, who granted it to you, who granted it to your prior owner, and back and back and back in that chain of title. And as an exhibit or an attachment, you provide the deeds, copies of the deeds from the recorder's office. So you get copies of your chain of title, and it's like an abstract, it's like a title abstract. Some people call it a title abstract. It's called a report of conveyance, and you submit that to the state engineer's office, and we update title, you know, after reviewing it, and if it's correct, we update title. So, yes,
998 East,
Before you do
North
that,
Union Avenue.
yes.
can I ask you, how do we get a copy of that, what you said, application certificate, or whatever you said?
Okay, good question. So here we are. She wants to know how to get a copy of the water right information or the application certificate. So here's a certificate. If you go to the water right database, which is waterrights.utah.gov, and you put in, you know, you can do it by map search like we've done, or you can do it by water right number.
You said that this would have the time that we had to show beneficial use.
Ah, yeah, okay, so, okay, good question. Okay, let me recall our conversation between us and you. It was, okay, I was going on the information that you had provided me. It sounded to me like you had an application in the state engineer's office that you were pursuing to get your water right established. Looking at the selection of documents available on this water right, it looks less and less to me like that's the case, and more like the water right's already established. The water right's already established, and there's nothing more to do or nothing more to develop under the water right, unless you're changing something.
So we have 7 years to show beneficial use,
You're changing.
right?
So you have, so, okay, let me just tell it to you from our perspective. From our perspective, this water right is established, okay? It was established in 1979 with proof. So, you know, the people did the works. They, I think it was a well, if I saw correctly. They drilled the well. The well was drilled. I even might have the well driller's log, or I might not. So no well log on the file, no apparently well log. So it's a 294-foot well. No well log. But it's been established. So if you're, I guess you're rigging up pump and electrical to pump the water out of the well. That's what you're telling me.
It has one in it.
So you're fixing it.
But I'm fixing it.
You're fixing it. Okay. So as to the 7-year period of beneficial use, you would have the 7 years from when it ceased to function until you get it fixed. To get it fixed so that you place the water to use so that you don't have a period of 7 years in which it went unused. You want to avoid that period. You want to avoid having that period fill itself out.
So for this purpose, though, you're going to be done with this purpose by 2020?
Yes.
Or in the next year and a half, right?
Yes. So we're going to come, so you're going to file a claim and we're going to say, well, when was the water last used? And presumably the answer has to be within the last 7 years, or else your water right is maybe, it may be at risk of forfeiture.
Okay.
Okay. So place it to use as soon as you can.
Yeah, it's expensive to do that.
If I've got a well that, it looks like I've got to do serious reconditioning of it, it might be, 40 grand. It's a huge burden. Can I ask for an extension?
Okay, in this particular adjudication process, if you have a well that needs refurbishing and you need time to do that, the adjudication doesn't really allow for that. The adjudication is more of a broad investigation. After you file your claims, we investigate, well, is the water in use? It is or it isn't. It has been or it hasn't been in the last 7 years. And that's kind of the end of that. Do we get extensions of time, he asks. To file a claim, you file a claim within the 90 days. If you need an extension of 30 days, you request that of the state engineer in writing, and the state engineer can grant 30 days. But as to extensions upon extensions, in order for you to place your water to beneficial use once again, there isn't that, that's not a remedy. So does that help? So we were going to look up an address here. What?
Just real quickly, if I've got the well and I haven't used it in that period of time, can I just drop a pump down in there and water on the garden and start at 7 years old?
Yeah. So this gentleman's only gonna. It's not going to cost him 40 grand to refurbish his well. He's going to drop a pump down there tomorrow and start using the water. Yeah. So, your address.
998, E for east, spell out North Union Avenue.
If you guys have more individual questions, you have staff back here that can address it individually too.
Okay. Does it look like a parking lot?
Pull back out a bit.
I'm trying. I'm working on it. I'm getting there. Looks like a circle here.
It's to the east of where you are. Right there.
Yeah, for some reason the search function didn't find it. I see the 998 on the map when I zoom back out one, but I don't know why it placed the X up here, so that's okay. It's not a matter of where it placed the X as much as it is a matter of if we can find it and if there's a water right associated. So the closest water right would be these couple of wells. And there's a couple more down a little bit further south. So it says Creekview Salt Lake LLC, which, it could be anybody's business entity, who knows. It says that it's used for livestock watering, so that may have changed in many years, right? But the amount of livestock that it's for is 15 head of horses and cattle, or the equivalent. We could, beavers, yes. We could very well look up what it meant when it said 15 head, what it meant here on the proof. The proof says that they used the water, and if I go to page 2, I'm going to guess is where I need to be. $500 beaver, which calculates out to 15 equivalent livestock units. So there's a division, you know, you divide 500 by whatever and you get 15 livestock units. 3 per 100. 3 livestock units, 3 livestock units per 100 beaver. Anything else? I'll check one more time on the water rights adjudication, and it looks like it is empty.
We have a half dozen people on YouTube, if it's okay, I'll go ahead and.
You can close out the YouTube. I don't know if I look that beautiful. Goodbye, everybody. Yes, I don't mind. So let's see.